The Eighth Amendment to the U.S. Constitution, made applicable to the states through 14th Amendment, prohibits excessive bail as well as cruel and unusual punishment. Even though the United States Constitution does not define what cruel and unusual punishments are, courts, particularly the Supreme Court, through many cases were able to establish a framework for defining what constitutes cruel and unusual punishment. From the public perspective, any punishment that is inhumane or that violates basic human dignity may be deemed as cruel and unusual. However, even though the structure of the prohibition on cruel and unusual punishments was given, this part of Eighth Amendment still causes debates among legislators and creates unsolved gaps in the legal system of the United States that have caused many convicts to experience inhumane treatment in prison climates. In this research project, I will talk about the meaning behind cruel and unusual punishments and how we measure a particular punishment's cruelty. In order to argue my position, I will utilize multiple court cases where the punishments are so disproportionate to crimes as to constitute violations to Eighth Amendment. And I will start with proportionality of sentence. The principle of proportionality is deeply rooted in common law jurisprudence. It was expressed in Magna Carta, applied by the English courts for centuries, and repeated in the English Bill of Rights in language that was adopted in Eighth Amendment. When the frames of the Eighth Amendment adopted this language, they adopted the principle of proportionality that was implicit in it. Nevertheless, the following series of flawed opinions from the Supreme Court prove that the state of the law with respect to proportionality in sentences is confusing and what law can be discerned rests on pretty weak foundations. In Solon v. Helm, respondent was convicted at South Dakota State Court of uttering a no-account check for $100. Ordinarily, the maximum punishment for that crime would have been 5-year imprisonment and a $5,000 fine. Respondent, however, was sentenced to life imprisonment without the possibility of parole under South Dakota's recidivist statute because of his 6 prior felony convictions, 3 convictions of third-degree burglary, and convictions for obtaining money under false pretenses, grand larceny, and third offense driving while intoxicated. The South Dakota Supreme Court affirmed this sentence. After respondent's request for commutation was denied, he sought habeas relief in federal district court, contending that his sentence constituted cruel and unusual punishment under the 8th and 14th Amendments. The district court denied relief, but the Court of Appeals reversed. In this case, the Supreme Court held that a sentence may not be disproportionate to crime committed, regardless of whether the crime is a felony or misdemeanor. To measure proportionality, the court must look at several factors. These factors include the severity of the offense, the harshness of the penalty, the sentences imposed on others within the same jurisdiction, and the sentences imposed on others in different jurisdictions. In Rummel v. Estelle, William Rummel was sentenced under a Texas recidivist statute that required life imprisonment for anyone convicted 3 times for a non-capital felony. He argued that such sentence was disproportionate to the offense of which he was convicted, or even to the sum of 3 aggregate felonies that were used to trigger the statute. Rummel was convicted by a jury in 1973 of theft for obtaining $120.75 by false pretenses. Under the relevant Texas statute, theft of more than $50 was punishable by the 2 to 10 years in prison. The state, however, chose to prosecute Rommel under the Texas felony recidivist statute. Rommel's two previous felony convictions were a 1964 plea of guilty to fraudulently using a credit card to obtain $80 worth of services and a 1969 plea to passing a forged check of $28.36. Rommel had received prison terms of 3 and 4 years respectively for these two prior convictions. After his 1973 conviction, the trial judge imposed the life sentence mandated by the recidivist statute. The Texas Appellate Court rejected Rommel's challenge to his sentence both on direct appeal and later on collateral attack. After his petition for habeas corpus was rejected by the federal district court, Rommel was successful in getting his sentence overturned by the United States Court of Appeals for the Fifth Circuit. A panel of that court determined that Rommel's sentence was grossly disproportionate to the offenses he had committed and therefore was in violation of the Eighth Amendment's prohibition against cruel and unusual punishments. In recent years, there has been a growing bipartisan consensus that the uniquely American policy of mass incarceration is both fiscally and morally unsustainable. The excessive nature of punishment in the US is not based on a rational analysis of incarceration and the fundamental objectives of sentencing policy. Moreover, unduly long prison terms are counterproductive for public safety and contribute to the dynamic of diminishing returns as the prison system has expanded. Next, I'm going to talk about insanity and mental illness. Nowhere in our society is the debacle of deinstitutionalization felt more than in our criminal justice system. According to data collected by the U.S. Department of Justice, in 2015 there were 2,186,230 prisoners in local jails and state and federal prisons in the United States. The best studies suggest that approximately 10% of prisoners have severe psychiatric disorders. Thus, approximately 218,000 individuals with severe psychiatric disorders are incarcerated in the nation's jails and prisons at any given time. Thus, the nation's jail and prisons have become de facto the nation's largest psychiatric hospitals. Marianne Hungerford has a severe form of borderline personality disorder that led to her numerous suicide attempts. As her mental state deteriorated, her husband of 26 years left her. Alone and unable to support herself, she began a relationship with a man who she helped to commit a string of armed robberies. She never even touched the gun the man used for the robbery. Even though this was her first offense, Hungerford was sentenced to 159 years in federal prison. The details of Hungerford's case do not match her over a century sentence. She took no active part other than driving the man to or from the scene of the crime or casing the stores that he later robbed. As one of the judges who reviewed her case explained, together they stole fewer than $10,000. No one was injured during the crime. The man turned down Hungerford in exchange for leniency in his sentencing, and he got 32 years. At trial, a psychiatrist testified that Hungerford had a very low capacity to assess reality and low level of intellectual functioning. Revealingly, people who commit much more serious crimes can receive a lighter sentence. As the First Circuit Court of Appeals has explained, under federal law, an aircraft hijacker, a terrorist who detonates a bomb in a particular place, a racist who attacks a minority with an intention to kill and inflicts permanent injury, a second-degree murder, and a rapist would all be subject to less harsh sentence than Hungerford got. And Marceline thought her daughter's schizophrenia was under control. And 34 had her own apartment in New York City, a steady job in a law office, and was studying for the law school admission test. She seemed stable, so stable that to clear her mind before the test, she decided to stop taking her medication. It wasn't long before she had a psychotic break and ran away. Something that has happened at least once before when she ended up in Georgia in homeless shelter and a county jail. This time, she turned up in Bucks County, Pennsylvania, nearly 100 miles from her home. Ed was arrested while walking down the street, suspected of stealing cash from the register of a gas station. That was nearly 2 years ago. Ed has been trapped in the Pennsylvania justice system ever since. If she wasn't convicted, why the hell is she there? You know she's ill, her mother said. A Pennsylvania judge deemed Elle incompetent to stand a trial because of her mental illness. After such a ruling, defendants are usually transferred to a mental health facility in hopes of stabilizing them enough to eventually appear in court. But Pennsylvania is one of many states that has far too few hospital beds for mentally ill defendants who need them, leaving people like Elle to languish in jail while they wait for a spot. It has ranked among the worst states when it comes to these wait times, a nationwide problem that experts say may be linked to the downsizing of psychiatric hospitals and inadequate community mental health resources. The 18th Amendment to the Constitution prohibits the government from inflicting cruel and unusual punishment upon its citizens, even its convicted ones, and especially the mentally ill ones. Jails and prisons are not created to be de facto mental hospital. They are not structurally appropriate for patients, and the staffs are not recruited as psychiatric caretakers. Not surprisingly, there are many problems associated with placing large numbers of seriously mentally ill individuals into jails and prisons. This misdirection of the mentally ill to prison violates standards of fairness and decency in the context of the proportional punishment of those who break society's law. And my last point, I'm going to talk about falsely accused to the death row. The death penalty has been considered for many years as one of the most controversial topics in American history. In the United States, there have been 2,095 exonerations of innocent inmates since 1989. In that time, an average of 8.7 years was spent by each person for a crime they did not commit. In total, over 18,250 years were solved. The Innocence Project reports that 2 to 5% of people serving time behind bars are innocent, with about 2 million people incarcerated in the United States. A 2% innocence rate would be equivalent to 40,000 wasted lives in jail and prison. In Brown versus City of Houston, Alfred Wayne Brown was wrongly convicted and sentenced to death for the murder of a Houston, Texas police officer based on false testimony Harris County prosecutors obtained through coercion and threats. After spending a decade on death row for a crime he did not commit, Brown was finally released with the help of his attorney Brian Stoller. In a book about Brian's case, Stollers examined the decade-long litigation, describing how they realized upon investigation that every witness had been pressured and frightened by the prosecutor, who used tactics such as threatening to charge witness with crimes in order to secure Brown's conviction. Stolas called this Harris County culture of conviction. Brown's girlfriend, Erica Dockery, who had initially testified before the grand jury that Brown was at her apartment during the time the crime took place, became a critical witness against Brown. As Stolas explains, Dockery's choice to abandon the truth, commit perjury, and testify against Brown came only after this prosecutor brought a baseless perjury charge against her for truthful grand jury testimony and jailed her with a bond so high she couldn't pay it. In what can only be described as luck, the retired case detective found a box from the case while spring-cleaning his garage, and the box contained phone records that supported Dockery's initial testimony and consequently Brown's alibi. This evidence, along with other witness recantations, helped with Brown's release in June 2015. Kennedy Brewer, who spent almost 15 years on Mississippi's death row for the 1992 murder and rape of his girlfriend's 3-year-old daughter, has been exonerated of the charges, and another man, Justin Johnson, has been arrested for the same crime. A 2001 investigation by the Innocence Project found that the semen of the victim's body did not match Brewer's DNA, but did match Johnson's. But what is more interesting, Johnson was a suspect early in the case, and his blood was collected and preserved in the Mississippi State Crime Laboratory for more than 10 years. And in the conclusion, I think that perhaps no section of the Constitution so dramatically reflects changing societal standards as the Eighth Amendment's prescription against cruel and unusual punishments. Some punishments are manifestly imperishable, but most have been viewed as necessary, if somewhat distasteful, responsibility of society. The Eighth Amendment has at various times been held to prohibit relatively mild punishments. At other times, however, it has been held to permit what would now be considered nothing but a pure torture. The history of the doctrine of cruel and unusual punishment supplies a good perspective of the problem, but presents no usable standard. Due perhaps to its rare invocation and general ineffectiveness, the phrase cruel and unusual met with surprisingly little debate before its inclusion in the Bill of Rights. It may well be that the phrase has been misinterpreted and given an application far beyond the original intention. Cruel and unusual punishment was defined as something inhuman and barbarous, something more than the mere extinguishment of life. Punishments that were manifestly cruel and unusual were prescribed. The real problem for courts seems to lie in the definition of that which is manifest. More particularly, they made ascertain the present state of the dignity of man and the evolving standards of decency that mark the progress of a maturing society. The effective application of the Eighth Amendment lies within these imprecise boundaries. Even though reforms in judicial system help to eliminate the infliction of intentional cruelty, little has been done to eliminate the sufferings of people whose sentences were so disproportionate to crimes committed as to constitute violations of Eighth Amendment and the decay of human decency. One of the greatest Russian philosopher and writer, Fyodor Dostoevsky, was right. He said, "How we treat our prisoners say more about us than about them." Thank you.